Okay, is that going to be your first witness?
No, my client will be the first witness, Your Honor.
Okay, so
I just
will she
didn't know if
be
you
able to
wanted
go
to
to a different room or go somewhere else?
Yes, ma'am. I can have her go out into the waiting room.
Okay, we're on record in cause number CR 2328766, State of Texas versus James David Head. Please state your appearance for the record.
Jessica McDonald, attorney for Mr. Head.
Shane Hazelton for the state.
All those.
Deborah Head.
A witness.
Witness.
Okay. All those intending to testify, please raise your right hand. Do you swear or affirm the testimony you'll give will be the truth and nothing but the truth?
I do.
Okay. And if Ms. Head can go to a different room?
Ms. Head, go ahead and just wait right out.
And Judge, I will have one witness who was going to be logging on here in a few minutes, but she'll be on, I believe, about a couple more minutes.
Okay. All right. Ms. McDonald?
Yes, Your Honor. By way of just a brief opening, I expect that through my witnesses today will show the court that the presiding judge, Judge Blake, who has presided in Fannin County for a number of years, so she often knows parties and players that come before her court, and that does not in itself rise to the level of any need to recuse her. I believe that the evidence will show today that in this particular case, my client, Mr. Head, is the ex-husband of one of Judge Blake's former court reporters. I believe that the evidence will show that there have been outside of the courtroom, outside of the just her interaction with him in the courtroom, that there were things like Judge Blake visiting when Mr. Head's ex-wife had a baby and things of that nature. I further expect that the testimony will show that the divorce between Mr. Head and his now ex-wife was quite contentious and ugly. And I believe the evidence will show.
Before we even get into the courtroom today, you need to understand exactly what kind of case this is and who this defendant is. What you're about to watch is not just a legal hearing, but a textbook example of how personal choices, repeated bad decisions, and sovereign citizen-style thinking collide head-on with reality. The defendant here isn't facing his first DUI. He's facing his fourth. And instead of taking responsibility, he's attempting something we see over and over again in courtrooms across the country, shifting the blame to the judge.
B, Rule of Civil Procedure 18B, that you recuse Judge Blake because she very well may have a personal bias against Mr. Head based on her interactions with him and other members of his family. And if not, then we're asking that you grant that under 18B1, that the impartiality might reasonably be questioned. We want our justice system to not even have the appearance of any impropriety. And so with all the factors we expect to show you today, we ask that you find under 18B 1 and or 2 that Judge Blake should be recused from this particular case. I'm sorry, I couldn't hear that, Judge.
You can call your first witness.
Thank you. I would call James Head. Mr. Head, please state your name for the court.
James David Head.
How old are you, Mr. Head?
46.
And how long have you lived in Fannin County?
For 30 years.
Now, you are currently under an indictment for a DWI third offense, and that is being that case was indicted into the 336 Judge Blake's court. Is that right?
Yes, ma'am.
Now, Mr. Head, Did you know Judge Blake at all prior to coming into her courtroom the first time for this case?
Yes.
And when is the first time that you met Judge Blake?
I met Judge Blake going nearly 14 years, November, when my last child was born. And
And who's your last child, and who was the mother of that child?
Shannon.
I'm sorry?
Shannon, which her maiden name was Sutter.
Okay, Shannon Sudworth. And so Shannon, if we say Shannon, use that first name, that is your ex-wife, is that right?
Correct.
How long were you and Shannon married?
We were married 11 years.
And what does Shannon do for a living?
She's a stenographer, court reporter.
And did she ever work for Judge Blake?
Yes, she freelanced with Blake in the past.
Okay, so in other words, Judge Blake has a court reporter that's assigned and in her court most days. Is that right?
Correct.
Shannon did not work as.
Right here is where the defense lays all its cards on the table. And you can already see the problem. Notice what they're not arguing. They're not claiming the judge violated procedure. They're not claiming the judge ruled outside the law. Instead, they're leaning heavily on appearances and personal history. The defense wants the court to believe that professional familiarity in a small county somehow equals personal bias. But in rural jurisdictions, judges, attorneys, court reporters, and families often know each other. That alone does not trigger recusal.
You had not met Judge Blake prior to that, correct?
No, ma'am.
Did you, so were you aware at that point that your then wife had worked for Judge Blake?
Yes.
Okay. And so did you, were you actually still in the hospital with the baby?
Yes.
Okay. Where was your daughter born?
In the hospital in Greenville. I don't know the name of the hospital. But it's in
And
Greenville.
so Judge Blake traveled to Greenville and visited there. Is that right?
Correct.
What year did you and Shannon divorce?
In 2017.
And can you describe, was that an amicable divorce? Was it contentious? Can you describe that?
At first it was both sides, and then it started getting real contentious at the end.
Now, your divorce was not in front of Judge Blake, is that correct?
Correct. No, it wasn't.
It was here in Fannin County, though, is that right?
Yes.
Did Judge Butler preside over that matter?
Judge Butler did, yes, sir.
Okay. During the divorce, would you describe that? How would you describe things between you and Shannon? Well, let me ask you this. Today, do you and Shannon maintain a civil relationship today?
No, we do not.
Do you speak to each other?
No.
Do you have any possession and custody rights to your 14-year-old daughter?
I do, but I haven't. We usually had like a week, every other weekend, and that was eliminated last February.
Okay. And did Shannon take you back to court for that?
No, ma'am.
How did that become eliminated?
She stopped coming to my house to stay every other weekend, to where my boy was staying every other week.
This moment is absolutely devastating to the defendant's argument, and he doesn't even realize it. On the record, he just admitted that the judge brought flowers and a gift for both parents after the birth of their child. That's not favoritism. That's courtesy. And here's the bigger issue. Bias requires hostility or unfair treatment, not kindness. If anything, this testimony undermines the entire recusal request. Add to that his own admission that his memory of the event is vague, and suddenly the cornerstone of his argument becomes shaky at best.
She keyed my ex-wife's car after a hearing with Judge Butler in Judge Butler's court. And Shannon, my ex-wife, filed charges against her for that.
At least we know where he gets his antisocial behavior from.
Okay. So, and to be fair, your mom pled guilty, said she did that. Is that right?
That's what, yes, she did.
But the keying of the car, the Criminal Mischief Act, happened during the course of the divorce between you and Shannon.
Yes. Yes, it did.
I'm sorry. Okay.
It did, yes.
And that case was prosecuted in front of Judge Blake.
Yes.
Do you have reason to believe that Judge Blake has a personal bias against you?
I do.
Objection, calls for speculation, Judge.
Sustained.
Do you feel like you've been treated fairly in front of Judge Blake?
No, ma'am, I haven't.
Why not?
I'm not think it's I mean, it happened with my mother and now it's happened to me now. And with the way I've been out on bond, I've done everything that I was asked to do. Maybe not in a timely manner, not on my part, but on getting these devices and all this. And I mean, I feel like that she's really biased against me just because of my past with my ex-wife. I don't know if she's like taking sides or what, but it's just, I'm not getting a fair trial on this.
You were, when you were first arrested on the offense that's currently in front of you, you were, a bond was set and you made that bond and bonded out of jail. Is that right?
Yes, ma'am.
The magistrate who set your bond, did they put conditions on you of having to wear the scram device?
No, ma'am, they didn't.
When Judge Blake reviewed your bond, did she add that device?
Yes, she did.
Now, you understand that Judge Blake can amend bond conditions as she sees fit to protect the community.
Correct.
Do you understand that?
Yes.
Okay, so that in and of itself is not anything to show that she treated you unfairly. Would you agree with that?
Well, when I first got out on bond in May of 2023, I didn't have any bond conditions.
This is where the broader picture comes into focus. What we're really seeing isn't judicial bias. It's the natural consequences of repeated poor decisions. Fourth DUI, license issues, jail time, bond violations, family distance. The defendant frames this as unfair treatment, but courts see patterns, and patterns matter. Judges don't operate in isolation. They evaluate risk, compliance, and credibility. When someone repeatedly insists that rules don't apply to them, whether through sovereign citizen arguments or selected
and that you attend and participate in the freedom of choice drug and alcohol program, is that right?
Yes.
And you understand that she's mandated by law to order that you have an interlock device on your vehicle, and she did that, is that right?
Yes.
Now, did you, through me, ask this. Did you at one time inform Judge Blake that you wanted to represent yourself?
Yes, ma'am.
Do you still at this time wish she would have allowed you to represent yourself?
Yes.
Did you feel like Judge Blake allowed you to represent yourself?
No, ma'am.
Tell the court why you feel that way.
Because she just the way I feel it is that she thinks that I can't take care of my own affairs. I'm an infant in her court.
And now I was appointed first as standby counsel. Do you understand that?
Yes,
Where you could still represent yourself, but she had me basically there's support for you. Is that right?
correct.
Did you want that?
No, ma'am.
Okay. Do you now when I was appointed, I filed a motion at your request for the judge asking her to modify some of your bond conditions. Is that right?
Correct.
And here we have another critical piece the defense probably wishes wasn't discussed. The defendant's mother wasn't unfairly targeted. She was prosecuted because she committed a crime. Keying someone's car is criminal mischief. Plain and simple. Judges don't become biased simply because they enforce a law against a defendant's family member. In fact, failing to do so would be actual bias. This testimony unintentionally reinforces that Judge Blake treated everyone equally, including relatives of people appearing before her. If anything, this shows professionalism, not prejudice. The court didn't protect the mother, didn't excuse the behavior, and didn't retaliate against the defendant afterward.
I operate heavy equipment, and at a certain time, she was wanting to put deep lung devices on all the equipment that we operate. It was I was fine with putting it on my personal pickup to get back and forth to work, but she's seen other ways.
So let me ask you this, Mr. Head. The first motion to modify bond conditions, were you asking her to take into consideration that given the harvest season coming up, you were going to work extra long hours? Is that right?
Correct. Yes.
And the bond conditions that you attend NAAA 3 times a week, and that you attend and work with freedom of choice, were those putting an extreme burden on your ability to take care of your responsibilities at work?
The AA meetings I was doing online, which I was doing those 3 times a week. I could do that by my telephone in late evenings. I was doing those. With the freedom of choice, I got enrolled to it to get to get those classes started, and then I had to report in on August 2nd to check in for these bond conditions if I've done what I was told to do by Ms. Blake. Other than
so, just to get some background, when we filed the motion to modify bond conditions.
But bond conditions aren't suggestions. They're signed agreements. And later in this hearing, the prosecution will introduce documentation proving that those conditions were clearly spelled out and acknowledged. Judges don't issue warrants casually. They do so when conditions aren't met. What we're seeing here is not bias, it's accountability. Courts are tasked with protecting the public, especially when someone has multiple alcohol-related offenses. Monitoring devices, treatment programs, and restrictions aren't punishment. They're safeguards.
Okay. So that was reset. Did you make an appointment to try to get that put on your vehicle?
Yes, I did. I got with Smart Start and had to schedule a meeting. And I went to that meeting 2 days before I had court on August 2nd. And somehow that place in Denison, Shipman Communications, didn't have me in the system to have that interlock device installed that day. So I had to reschedule for the following Wednesday.
And your probation, the person you report to at probation was able to confirm that and inform the judge of that. Is that right?
Yes, ma'am.
But she had also said you had to get enrolled at Freedom of Choice. Did you have an appointment to enroll at Freedom of Choice?
I did, yes.
Were you able to make that appointment?
I wasn't. It was the week before I had that court on that Friday. And so I called and had it rescheduled for that following Wednesday, the same time that I would get the interlock.
This moment perfectly illustrates the danger of misunderstanding legal instructions or choosing to misunderstand them. The judge didn't randomly demand interlock devices on farm equipment. She addressed a loophole the defendant himself created by claiming he had no vehicle. If you drive equipment across public roads, it becomes subject to safety regulations. Period. The judge offered a clear solution. Put the interlock on a vehicle. Instead of doing that immediately, delays piled up, appointments missed, rescheduled, and misunderstood. When you strip away the emotion, the accusations, and the selective memory, this case becomes very clear. The judge followed the law. The bond conditions were lawful. The enforcement was justified. And the recusal request lacks the factual foundation required to succeed. This wasn't about personal grudges or favoritism. It was about repeated noncompliance and risk management in a fourth DUI case. The court acted exactly as it's designed to act. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.